Good afternoon, everybody. My name is Robert Baker. I'm a shareholder at Chartwell Law offices. I practice in Pennsylvania and Virginia. We are here today to discuss current issues in Washington, D.C., Maryland, and Virginia workers' compensation. A little bit about myself. I've been with Chartwell for approximately 15 and a half, 16 years. I've been handling workers' compensation and employment matters for in excess of 20 years in the private sector and in practice. Today I have with me both Jack Huskin, and Steve Tregay. I will leave it to Steve to introduce himself and tell everybody a little bit about his own practice.
Hey everybody, thanks for joining us today. I have been practicing nothing but workers' compensation for the last 24 years, I believe. And that is, I've done both the claimant side of things and defense side of things. The majority has been the defense side of things. I practice in Pennsylvania, the District of Columbia, and Maryland. And if anyone needs me to practice anywhere else, I'll gladly take another bar exam because I'm a glutton for punishment. I've handled workers' comp claims from soup to nuts, appeals all the way up through the Supreme Court here in Pennsylvania. And I've been with Chartwell. I'm a partner here at Chartwell. I've been with Chartwell for almost 5 years.
Jack, do you want to introduce yourself?
Sure. I'm Jack Huskin, and I've been doing comp for a long time in Maryland, Pennsylvania, and California. And I've been with Chartwell, I believe, 2 or 3 years? I don't remember anymore. I know it was before the pandemic.
It's been a long time, Jack.
That's right. So thanks for joining us, and I hope we can make it entertaining for everyone.
Yes, absolutely. Just a few ground rules before we start, if you don't mind. This is just the general disclaimer. We're attorneys. We have to give disclaimers. Nothing we're discussing today should be considered legal advice. We're happy to answer questions as they arise. I'd recommend that you use make sure I get this right because I had it written incorrectly earlier, the Q&A function rather than the chat function. Questions are encouraged. I'll try to answer them during the presentation as they come up. If for some reason we don't get to a question during the presentation, we will certainly follow up with you individually afterwards. We are going to talk about a few different areas, including a brief overview of workers' compensation, burdens and defenses, generally speaking, in each of the jurisdictions. We're going to talk a little about injuries that might be suffered while working at home, which is becoming an increasing hot topic, considering most of us have been working at home now for almost 18 months. A little bit about light duty programs in the respective states, and similarly related to COVID, some rise in mental claims and the respective burdens. So with that being said, I think we will get started. The process is that we have the presentation designed to go through each section by jurisdiction. At the end of the presentation, in the next day or so, you'll receive not only the PowerPoint presentation and a PDF file, but also a recording of this if you'd like to share it, or God forbid you're inclined to watch it again. But you will receive that information for future reference. Our contact information is included in the PowerPoint presentation. Please feel free to reach out to any one of us specifically, or if you would like to email me directly, I'd be happy to put you in touch with the appropriate person. But with that, Steve, why don't we get started with the presentation?
Okay, a brief overview of District of Columbia comp claims. So, claims such as single occurrence claims are compensable. That is, I'm working and I bend over and I pick up that box and I herniate a disc. That is going to be compensable so long as it is arising out of it in the course of employment. Also, interestingly, in the district, willful acts by third parties are compensable. I actually have a case right now where there was a argument in the street between two coworkers. The claimant was not the aggressor, but the coworker called some family and friends who showed up and severely beat the claimant. with hands and feet, that is a compensable injury. And something else that's interesting I find in the district is that there's a rebuttable presumption that the claim is compensable. It's actually up to the employer to show by substantial evidence that the claim's not compensable. And that goes for things like psychiatric injuries as well. Psychiatric claims are compensable, and so are occupational disease claims. And normally what we are always asked are, well, what defenses do we have to claims? Well, any injury that's self-inflicted, willful misconduct, if you're acting without authorization, if you're on a personal mission, and the personal mission is going to come up later in our presentation, and a violation of express prohibition. If you tell someone they are specifically not supposed to do something and they do it anyway, that could be a defense completely to the claim. And intoxication, so long as the intoxication was the sole cause of the injury. And a quick overview, the types of benefits that are available. Temporary total disability benefits, if you're out of work totally, that's 2/3 of your average weekly wage. There's temporary partial, which would be 2/3 the difference between the average weekly wage and current wages if they're on limited or light duty. And then the district is a permanent partial jurisdiction. So if the claimant reaches MMI, there's a statutory schedule as to what benefits might be payable, including legs, arms, et cetera, et cetera. And of course, medical benefits, so long as the medical benefits are reasonable, necessary, and related. And you do have the right as an employer to seek utilization review of proposed or previously rendered services. So that's a super brief overview of comp in the district. Let me toss things over to Jack for just a brief overview of Maryland.
No, actually, Steve, I could use your outline and just say that's what Maryland does too. It's all similar language. So similar language to DC, Maryland, to be a compensable accidental injury, it must arise out of and in the course of employment. And arise out of looks at the causation. And then the course of employment is more interesting, particularly when we get into injuries at home, because it contemplates time, place, and circumstances. And we'll get into that later when we're talking about injuries at home. The other interesting thing about Maryland is there's 2 recent cases that deal with this area of the law. And I believe the next slide may be the Schwann Food Company case, where a fellow fell outside of his home, and the Schwann Food Company court looked at whether or not his house was a place of employment. And in that case, the courts came up for Maryland with a definition of whether a home qualifies as a work site. And this is pre-pandemic, but there are 3 factors that the court looked at. And the first was quantity and regularity of work performed at home. The second was presence of work equipment at home. And the third was special circumstances of the employment, rendering it necessary and not merely personally convenient to work at home. And so the court didn't determine whether or not this was a going and coming issue because the claimant's home was a work site. They remanded it to look into the circumstances on whether or not it was a work site. And then the next interesting, fairly recent pre-pandemic case is the Montgomery City versus Mahoney case, which may be the next slide or so. And that was a fireman from living in Virginia, worked for one county in Maryland, and he was asked to do some training. And so the training was, I believe, in Rockville or somewhere far away from his home in Virginia. So after he completed the training late in the day, rather than go back to Virginia, he decided to go to a fire station that wasn't in his district and spend the night. He got up, did all sorts of things, and around 10:30 at night got up and hurt his foot. And so the Montgomery City case is very interesting because looking at the period of employment, place of employment, and whether the claimant was fulfilling those duties of employment is pretty difficult to see in that case, because he wasn't at a place of employment. He wasn't during the period of employment, and the court sort of stretched to say, well, the employer knew that he had this opportunity to rest at other district fire stations, so they basically found it a compensable claim. And that's just, I think, continuing on with that case.
So Virginia, I might say ditto with respect to the elements to prove. In Virginia, the elements are very similar to both Maryland and Washington, D.C. So for an injury to occur to have been found compensable in Virginia, the injury must be caused by an accident arise during the course and scope of claimant's employment, and notice has to be given within 30 days. Most conditions require a claim to be filed within 2 years. So Virginia has a 2-year statute of limitations. Benefits in Virginia are similar to other states where an employee might be eligible for temporary total disability benefits, temporary partial disability benefits, or permanent partial disability benefits, in addition to medical treatment. Interesting note about Virginia is the claimants are eligible for cost of living adjustments to the compensation rate. That is different than many other jurisdictions. Defenses to the claim, very similar in Virginia to other states, including intoxication, violation of medical restrictions or safety rules, violation of statute, and willful misconduct. So I think when you're looking at the context of burdens of proof and elements of a claim, these 3 states are somewhat similar amongst themselves, but also very similar to the burdens of proof or elements within other states. So with that, I think Steve will go to injuries that are suffered while working at home.
All right. So injuries from working from home. And I'm going to assume and do some analysis based upon COVID and based upon the fact that people have now been told you must work at home. Let's throw away, well, I was working at home because it was convenient. My employer says to me, Chartwell says to me, you need to stay at home because of COVID. We're closing the offices. The standard is going to remain the same. So long as the injury arose out of the course of the employment, it's going to be covered, and your defenses remain the same. So I like to sort of do the 2 ends of the spectrum analysis. If I am walking around my house dictating a letter on a specific file, and I think if I trip over a dog or I trip over a child and I smack my head on the counter and end up with a concussion, I think I'm in the course and scope of my employment when I'm doing that work because I'm doing something that's integral to my employment by dictating that letter. I think on the other end of the spectrum is, well, I got some work done, but now I really don't feel like working anymore, even though it is the middle of the day, and I decide to throw laundry in. And during the time that I'm throwing laundry in, my laundry room's downstairs, I'm walking downstairs, I'm a klutz, I trip over my own feet, I tumble down the stairs, I herniate a disc, and I also get a concussion. I think there you have an argument that I was on a personal mission. I wasn't doing anything for my employer that was furthering their business interests. I wasn't dictating. I wasn't even thinking about a case when I was doing that. I was just thinking about the loads of laundry I had to do because my son is a slob. And so I think that would take you out of the course and scope. But of course, you're going to be dealing with the myriad of claims that fit in between those 2 scenarios. And the question is going to become, was I acting without authorization? Was I on that personal mission? And whether or not the activity was momentary or minimal. I think if I'm working and I decide to use the restroom, that's no different than I decide to use the restroom while I'm in the office. If I hurt myself doing that, it's most likely going to be covered. And I think there are things as employers we could try to do to limit these claims, and that is establishing rules of what an employee can or cannot do while they're on the clock. I think if you make it expressly, at least in the district, if you were to make it expressly clear that you're not to do personal things at home, such as laundry, I I think you'd have a better shot at defending that case. You know, this is what you're supposed to be doing. If you're on the clock and you're working, you're to be at your computer, you're to be doing whatever your job entails. But the moment that you decide to do something outside of, I'd say outside of getting a drink, using the restroom, something that you'd expect to do in the office, and make rules that you're not allowed to do those things, you'd have a better shot at defending cases. You know, and regardless, it's going to be on a case by case, based upon the facts of each case.
So Steve and Jack, there has been a question presented, and I think we'll try to answer this in our respective jurisdictions. So the question is, what if working at home is optional and is not required? So in Maryland, Steve, does the fact that working from home is an option and not mandated in any way change, you know, the scenarios that you were discussing?
Well, I think that still becomes a course and scope issue. If it's an option that my employer has given me, they made it optional, I've chosen to take that option. The question is whether or not the activity I was performing at home took me outside of the course and scope. I mean, certainly, I think the inquiry is still, are you in the course and scope when you got hurt? I don't think that the option in and of itself would remove it. If the employer is saying you can do either A or B, but we expect you to be working when you're working from home, if you're in the course and scope while you're at home and you get hurt, it would still be covered.
What if I were to change the facts a bit, Steve, and I work from home, but my home office is in my family room in the basement, and I'm walking down the stairs from the first floor into my basement, and I have every intention of logging in for the day working on my computer. And while I'm walking down the stairs, I trip and fall down the stairs and break my ankle. How would you address that type of claim?
Well, I would tell the carrier to deny it, because I think at least you have a defense at that point. I mean, that becomes that's about as gray as you can get. My intention was to log on. I was going towards the computer and I hurt myself while I'm doing that. I think that's something it could go either way. I really think that could go either way. You know, I think a judge might see that as your intention was to go down there and start working while you weren't officially logged on. You had to walk down those steps to be able to log on and to further their business. Therefore, you're in the course and scope. But I think we have an argument that you weren't. Until you were logged on, you weren't in the course and scope. That's a typical lawyer answer that I just gave you, wasn't it? I didn't give anybody any information there. I just said maybe.
It depends.
It depends.
That was a great answer.
It turns out I am a better lawyer than I am an IT.
So I think, Steve, was there anything else that you wanted to add with respect to injuries working at home, or were you about ready to send it over to Jack?
I think I'm gonna go ahead and pass it off to Jack in Maryland.
Okay. So Jack, when you're discussing your section too, if you would just keep in mind the two scenarios: one, if working from home is optional and not required, and two, my very gray area of falling down the stairs on the way to my home office, spilling coffee on myself and breaking my ankle.
Actually, I'll address the one and just go to the language of Schwann Foods, where one of the factors to look at whether a home is a work site is whether the claimant was merely personally using the home as a personal convenience. And then the consideration in addressing that factor would be whether the employer acquiesced to the employee's use of his or her home as a work site, or reasonably should have known the employee was regularly using the home as a job site. So that would be the factor to determine if it's a voluntary or allowed but not mandatory issue to work at home, whether it's merely a personal convenience, or whether the employer knew the employee was regularly working at home and allowed it. Under the second question, I think it determines or depends on what is the home work site. Is it the whole home, or is it a home office? And then if it's a home office, then you fall down the stairs. Is that a going and coming exception, such that fall down the stairs would be compensable even if the whole home isn't the home office? And just continuing on with these issues, I mean, in Maryland, the Mahoney case sort of obliterated the 3 requirements of time, place, and circumstances. So I'm not sure where we stop. There has to be some limit on time and place, but where do we stop when we're working from home, whether or not it's a requirement? The other issue with these types of things is it's an underwriting nightmare, because you might be writing a policy for a company in Pennsylvania, and then the company's employees may be working from home in West Virginia and Maryland and perhaps Ohio. So that's a consideration. Where's the jurisdiction when all of these employees are working from home, particularly in a state like Maryland, when it's really easy to live in West Virginia and work in Pennsylvania, up around the Hagerstown area particularly. So that's the jurisdiction question, as well as the scope, as well as the fact that the employer doesn't have any control over this home work site. If you have a company and someone spills oil on the floor, you can make sure that that is cleaned up right away. But at the home, you don't know what's spilled, and you don't have the control to clean it up. So there are all these considerations. I think the courts are somehow going to put a place, time, and circumstances limitation, but I'm not sure where that would be, particularly in light of the Mahoney case, which sort of obliterated the time and place components. That's
So in Virginia, we look at an accident occurring at home really with respect to a deviation from employment scenario. So the primary issue is that if an accident occurs at home, at a place, if an accident occurs at a place where from the nature of the work, the employee may reasonably be fulfilling the duties, or it's something incidental to the employment, then it could be work related. So with respect to the voluntary option of working from home, that reasonably could be covered under the language of the Act. Similar situations to the scenarios that Steve was discussing, working throughout the office, the location, at home, that would be compensable unless there was a deviation where the employee had suspended for a purpose wholly unrelated to the employment or for a purely personal reason. Then that injury would not be compensable. In other words, you're looking at the extent of the duration, the extent of the deviation, how long was it, how substantial was it temporary in nature, or was it trivial or insignificant? So the issue in Virginia can become where there's this dual purpose. So if I am dictating in my home, I leave my home office, I'm dictating, and while I'm dictating, I'm throwing in a load of laundry under the dual purpose classification. If I am injured during that dual purpose, I could still have suffered a work-related injury because the employer's interest was still being served to some extent. In other words, I was still working on whatever claim or file I had been working on. If, however, I'm working from home and I leave to pick up lunch or my children or something to that effect, I would argue that type of deviation would be significant and an extent of deviation that would remove me from the course and scope of employment. With respect to my fact pattern where I'm walking down the stairs to my home office in the basement and I fall and break my ankle, this same type of analysis that Steve had presented with respect to coming and going may apply. So if that was where I was supposed to be working and the means of ingress or egress was only the stairs and that caused the accident, then again that would be within the course and scope of employment and would be compensable. So I think from what I'm hearing in our discussions previously that the analysis, maybe with the exception of Maryland to some extent because of recent case law, is somewhat similar throughout the area of Maryland, Washington, D.C., and Virginia. But again, these cases are so fact specific. I, like my colleagues, would certainly try to find a basis to deny and put the claimant to their proofs, so to speak. Next slide, Steve.
Doing light duty work. Is that the next slide? Light duty.
I think yeah, you're in. There should be another slide for light duty work in Washington, D.C.
Yep, I got it. So light duty. We've accepted a claim. The individual has been released with restrictions. What do we have to do to, well, I guess the first level of inquiry is, does the company offer light duty? Are there accommodations available? So let's just, and if they are not, then that individual is going to be entitled to ongoing temporary total disability benefits. But if you do have light duty available, there are certain things and hoops that, as a best practice, you should do. The first, I prefer to have everything in writing. I don't like oral job offers. That becomes muddied when we go to a hearing, and it can become a he said, she said. I offered you work, no you didn't. I never heard from you, but I called you on this day, no you didn't. And that devolves into the worst defense, which is liar, liar, pants on fire defense. It is not a good defense. It's not one that I recommend that we use. So I would say send that letter, and it should be, and I would send it return receipt requested, so there's proof that you sent it and they received it. If represented, you have to send a copy to his or her attorney. And then I would set forth the confirmation of the restrictions. I would, in fact, if you have a copy of those restrictions from a doctor in writing, I would enclose a copy of the actual restrictions from the doc. I would outline the descriptions of the work duties to be provided, the location, the start time, all those things that you need, including who the claimant should contact about making the final arrangements, or outline it in the letter. You're to contact Mr. Smith. We expect you to return to work on this date at this time. I would also put in the wages. Are they going to be earning what they were earning prior to being hurt? And obviously the hours they're going to be working. It's also a best practice to provide the modified duty description to the treating physician in writing for a co-signature, because that doctor is the one who's placing the restrictions. It's smart to have them review them and agree that they could do the job as outlined. And the next question becomes, well, how can we cut someone off if we offered a job and they haven't returned to work? So we would need to produce evidence that the employee unreasonably refused the modified work. And then you may, at that point, the court would consider it a voluntary limitation of income because they didn't return. And I think the best way to prove that is we have the writing. This is what you were expected to do. Even put at the bottom of the letter, I'm going to accept this job. I'm not going to accept this job. So that when we go to a hearing, we have proof that they were offered the job. Everything outlined was within the restrictions. They were going to be earning what they were earning before, and they simply chose not to show up. So that's kind of in a nutshell what I would do when it comes to light duty work. Jack, Maryland.
I agree with you, Steve, because Maryland doesn't have anything like Pennsylvania's Kaczynski standard in terms of requirements to make a job offer. But I agree with you. It should be in writing, and you should give all the information about the job that the Kaczynski standard in Pennsylvania requires. As far as offering, I mean, it's sort of elementary. If you have work, it's favorable to offer it because you can reduce or eliminate your exposure to indemnity. If the claimant is at maximum medical improvement, you don't have to pay wage loss benefits, but then the claimant can demand vocational rehabilitation benefits, which lots of times is just as bad or worse in terms of exposure. So that, in a nutshell, is my opinion on Maryland job offers.
Again, I would agree with both of these very intelligent gentlemen that the best action is to extend job offers in writing and document the date, time, location, wages, type of employment that's being offered and the medical restrictions that are being relied upon. Because in Virginia, much like other states, employers are not obligated, first of all, to offer light duty if work isn't available. But an employee, if work is available, the claimant can refuse an offer of light duty if it falls outside of the restrictions. There are different options of addressing the claimant's, the employee's obligation or burden to search or seek for light duty work, depending on whether or not the individual's under an open award. Next slide, Steve.
Yep.
Much like other states, if the job offer, light duty job, pays less than what the employee was earning pre-injury, there would be an entitlement to partial benefits. Virginia is interesting in that it also provides a mechanism for vocational rehabilitation services. So if an employer is unable or unwilling to accommodate light duty work restrictions, then vocational rehab could be initiated, which includes job coaching and retraining, albeit at the employer's expense. Through the job search efforts, an employee has an obligation to comply with the commission's marketing guidelines, which is essentially an employee's good faith effort to search for work who is unable to perform his or her regular job, but perform some sort of light duty. Next slide, Steve. The guidelines are not all that extensive, but if the commission were to look at whether or not a reasonable effort was made by the employee to search for light duty, they would look at things such as nature and extent of the disability, the employee's age, vocational and educational background, the extent of the job search, availability within the employee's suitable job area, or other factors. When looking at these types of cases, the commission could look to suspend indemnity benefits for violation or failure to comply. Next slide. The employee should maintain, it's a form, a list of job searches and marketing efforts to find a job, and that is submitted then by the employee through what is called the web file system, or faxed directly to the system as proof of the efforts of the employee to find other suitable employment. Next slide, Steve. Of note, usually an employee cannot turn down a light duty job simply due to childcare. That is pretty significant, a significant difference than other jurisdictions. For example, in Pennsylvania, if a modified duty job is extended to an employee that would conflict with childcare obligations, that would be a basis in Pennsylvania to refuse the job, at least a basis to argue to the judge to refuse the job. Typically not the case in Virginia. Another interesting note that if the employee in some way attempts to purposely sabotage the rehabilitation process, interaction with the counselor, or refusing appropriate light duty work, those are also options for a possible suspension of benefits. The mechanism generally for refusal of a specific job offer, we would file what's called an application for hearing with the commission via web file, and submit the basis for our application and our request to either modify or suspend and include supporting documentation, and then eventually a hearing would be heard. I'm just going to check there are no additional questions as of right now for light duty. So I think with the time that we have remaining, we'll discuss the rise of mental health claims, and then we'll leave a few moments for question and answer at the end.
Absolutely. And before we move on, I would note since the two of you talked about vocational counseling, that's also available in the district. Same thing, it's at the employer's expense, assuming the person can't go back to their regular job. And in many respects, we have to hire the vocational counselor. The claimant does have to meet with them. Job leads would be, we found the claimant has to follow up with those job leads. And assuming the claimant is refusing to cooperate, we could cut off benefits at that point. Again, you'd have to go through a hearing and all that to do that, but it is possible. So that being said, next topic, mental health claims. So in the district really covers two types. Let's deal with two types of claims. We call them in Pennsylvania mental physical claims or physical mental claims. Those are claims that are physical injury and it leads to a psychological injury. So again, I'm lifting up the box. I blow out a disc in my low back. I have to have surgery. After the surgery, I have pain that doesn't appear to be going away, and I become depressed because of that. That is going to absolutely be covered under the district law. They are, and interesting, I discussed earlier about the presumption in the district, that there's a presumption that the work injury is compensable or that it occurred within the course and scope of the employment. The same goes for for psychological cases. It is up to the claimant to invoke that presumption. And I don't want to bore you by reading, but it's on the slide. There's this presumption. The claimant says, I'm invoking that presumption. It is then the employer's burden to show by substantial evidence that the psychological injury was not caused or aggravated by the workplace condition or events. If we're able to succeed, the statutory presumption drops out of the case entirely, and the burden then reverts to the claimant to prove by a preponderance of the evidence that the workplace conditions or events caused or aggravated the psychological injury. But the type of psychological injury when we're dealing with the physical injury, which is then followed by some sort of depression, that is going to be compensable. Anything that flows directly from that initial injury is going to be compensable. The more difficult case is the mental case. And these again are the types of cases that can be found to be compensable. We have this presumption that it's compensable. And I like to point out a particular case, and it deals with PTSD. We have to remember also that the psychological injury test for the district, it's subjective, not objective. It was originally objective, but the appeals court overturned this. So the question isn't whether or not an ordinary employee would get PTSD. The question is simply whether or not this employee got PTSD. And the facts of the case were 5 coworkers were told that their positions were going to be eliminated as a result of an internal reorganization. The Court of Appeals held that the question was whether or not the claimant's termination caused the employee to suffer from PTSD, not whether termination from employment would normally cause PTSD. So it's a very claimant-oriented jurisdiction when it comes to psychological claims, because I would think that an ordinary person would not get PTSD because they're going to lose their job. Unfortunately, under the district law, if this particular claimant can prove, and they still going to have to present medical evidence from a psychologist or a psychiatrist saying that they do have PTSD and that it was caused because they were told they were going to lose their job. And we certainly would have the right to an IME to a doctor that would say otherwise, but it is definitely a slope that is favored towards the claimant. And there is also kind of one interesting caveat in the district is that emotional injuries sustained as a result of sexual harassment have been held not to be covered by the Act. And in fact, the claimant is to pursue civil remedies for harms such as psychological injuries as a result of sexual harassment. So that is outside of the scope. But things like PTSD, depression, all those types of things, they are going to be found. Well, there is this presumption that they would be work-related if the claimant chooses to invoke that presumption. I think that's what I've got for the district. Jack, what's it like in Maryland?
In Maryland, up until the Belcher case that I cited on the slide, the thought was that a personal injury did not include non-physical injuries under the Maryland Workers' Compensation Act. But in the Belcher case, Belcher was an office worker and she was sitting at her desk when a 3-ton beam crashed without warning through the ceiling in her office and landed 5 feet from her desk. This was in downtown Baltimore when they were building a high rise. So Belcher case, the court explained that mental injuries can be as real as broken bones and capable of objective determination, and therefore allowed a non-physical injury to be included under the Act's definition of personal injury. And the court just remanded it so claimant could present objective determination that the event that caused her to suffer a psychological injury did cause it. And so she would just, or the claimant would just need medical proof, a psychological report connecting the condition to the work incident, and you likely have a compensable claim.
Similarly, in Virginia, to have a compensable injury as an injury by an accident, it must be causally related to a physical injury or related to what is considered an obvious sudden shock or fright arising from the course of employment. The commission has noted that words or disagreements alone are insufficient, such as management decisions and conflicts with supervisors and their staff, while stressful and may result in psychological disability, that is not necessarily compensable. The commission has said that past problems associated with personnel and management is something that's inherent in all employments and is not, through words alone, sufficient to constitute an accident. However, if an employee has compensable injury, such as Steve's low back injury, and that injury aggravates or causes mental stress or depression, then that aggravation or cause may be compensable. For example, if someone has chronic pain, that chronic pain causes depression, then the depression, if proven medically by the claimant, would be compensable. As I said, there has to be a connection between the accidents and the stress or stressor causing the depression. Next slide, Steve. And that would be similar to what Steve had categorized as a physical mental injury. Virginia also has something similar to the mental claim. And these are situations where the claimant develops mental stress resulting from a specific incident. An example of this type of obvious sudden shock or fright, easy for me to say today. A typical example would be if a rescue squad worker goes to the scene of an accident, the accident is rather horrific, and the rescue squad worker develops a mental impairment due to the exposure at the accident. Again, if it's medically proven with medical evidence, that could be one of those obvious sudden shock or fright situations. Another scenario is if the employee's work is particularly high stress, it is possible for the employee to show a mental stress characteristic with the employment. For example, if the emergency dispatcher that was employed in an occupation where stress was characteristic of the employment, that could be something that would be considered to be a mental stress component of a claim. When I was preparing this, the first thing that kind of came to my mind was similarly to air traffic controller, where it's a high stress occupation. and whether or not that could be something that fell within this mental stress characteristic. Obviously, in Virginia, based upon the language I read, that is certainly a possibility. But we have some time remaining, Jack and Steve. I wonder the scenarios that I have here on the screen and possibly the air traffic controller situation, how would those types of injuries fall within your respective jurisdictions?
Well, in DC, so even though it's a high stress occupation, if the work induced whatever psychological injury I have, under DC it would be compensable. And I don't want to seem glib that like, oh, an individual says they have PTSD, therefore you need to pick it up. It's no different than any other jurisdiction in that they are going to need to present, you know, a deposit. Actually, in DC, you're going to have to present a deposition from a doctor saying that not only do they have PTSD, you know, they meet all the requirements, it was related, and we have the right to that IME and our own doctor as well. So I don't want you to think that, hey, we're in the district, we have an injury in the district and this person says they have post-traumatic stress because they're being fired, and hey, there was a case out there, therefore we should pick it up. You should not pick it up. I mean, they're still going to need to jump through all the hoops and actually prove that they have the PTSD. I'm just laying it out there that I think if it is a tie, the tie does not go to the employer. I think at that point, the way the statutory scheme is set up, it is tilted towards the claimant.
I think that applies for all the jurisdictions that we're discussing. And I don't know that any one of us are suggesting that we're trying to scare you into acknowledgement of everything. I think the opposite is true. Is we're trying to outline, provide a roadmap and outline some of the potential pitfalls or issues to consider. But like Steve, I know Jack and I also would suggest denial, putting the claimant to their proof, so to speak, of making that causal connection between whatever they're claiming, whether it's a mental or physical injury, and their employment and incident at work. But Jack, what about just to kind of wrap up the application of Maryland law to these scenarios?
Well, actually, Maryland law, that's what I've said before. There's not a lot of Maryland law because when you go before a commissioner, the commissioner has wide latitude in making these determinations, and he's going to have claimant's psychiatric medical report, and he's going to have the defendant's psychiatric medical report, and he's going to look at the circumstances and either find a work-related mental injury or deny the claim. And when that happens, the reason there's not a lot of Maryland law is because in Maryland, if you don't like the commissioner's determination, you go into a regular civil court with a jury trial. With that expense, there are not a lot of cases that go up on an appeal. And of the cases that do go up on an appeal, I'd say probably 90+% are settled. So there's not a bunch of cases out there saying that if someone gets their feelings hurt at work, that's non-compensable or something like that, because they usually, probably 90% of the cases are resolved at the commission level and go no further than that.
And it sounds like, Jack, I think you mentioned that that is largely in part due to the cost, right, of going from the equivalent of the Virginia Commission to a jury trial before a judge. That's
right. I mean, on an appeal, if the claim is denied and the claimant who got his or her feelings hurt at work and claimed a mental health injury, the appeal cost is sort of exorbitant because that claimant is going to have to pay out of pocket, $5,000 for a psychiatric expert's deposition, and then also pay all the court costs and go to jury trial. So that doesn't happen very often. And the appeals that are filed, most of them are settled without having the claimant expend that kind of cost.
Well, thank you both, gentlemen, and thank you, the attendees. We are finished with the presentation. I think we'll just wait a minute or two to see if there are any any questions that we could answer. If you don't want to pose a question to the group and you would like to contact us directly, as I mentioned, feel free. And after you review the information, once it's emailed to you, either later this week or early next week, please feel free to reach out with anything else. It's been a pleasure chatting with the two of you gentlemen, and we look forward to the next presentation and what I hope will be a series for DC, Maryland, and Virginia.
Yeah. Thanks, everyone. It was a pleasure.
Thank you.
Thanks for attending. Take care.